Alex here with part 7 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 of the series. That is my disclaimer video. It contains all of the details as to what the purpose of the series is. And just a couple of things I want to glaze over for the people that aren't going to watch the video first. Number one, my case is completely and totally closed. Please do not feel like I'm actually in the middle of the situation right now as you watch this video. My ex's parental rights have since been terminated. The case cannot be reopened. And I also want to mention that the purpose of this series is to provide my viewers with one big, gigantic example in chronological order from beginning to end as to my 8 years of representing myself most of the time in my high conflict child custody case. So this video picks up after part 6 a day later, and I believe that I did something similar in response to receiving the order of protection, which I discussed in part 2. I am still in that state of panic, and I am still reacting to papers that are filed within a day of having received them. This isn't recommended, and this is a recipe for disaster if you do something like this when it comes to motions. In fact, any type of paper that's filed or pleading that's filed in a legal matter is not, it is not a good idea to react the next day, because you will sometimes think of things over the course of waiting that you could have brought up in a particular paper or pleading. And so right now, because I am representing myself, because my ex has an attorney and has counterattacked with the order of protection, I'm still in a panicked state, and any paper that I receive or pleading, I am responding to immediately. And this video is no different. I received the answer and counterclaim from my ex's attorney. That is the first time that I had any idea that she had an attorney. It's the first time her attorney made herself known. And one day later, after having received the answer and counterclaim, I went to the courthouse and filed. This is the reply to counterclaim that I filed. The first thing I wanted to mention is I'm still using self-help forms. I've talked a lot about this in my previous videos, so I won't reiterate any of that again. I do emphasize or encourage a transition to custom papers and pleadings. In my previous video, part 6, my ex's attorney filed a custom pleading. Her answer and counterclaim was not a fill-in-the-blank style form. It was purely typed out, and it was custom. And so that is what I'm eventually going to pick up on, but at this point in the process, in this video, I still haven't keyed in on that. Later on, I will be using the format that my ex's attorney uses to sort of invent my own style as to drafting custom papers and pleadings. And I just wanted to remind everyone as to the fact that I'm still in the process. I'm still very new to the process. That's what I meant to say. And so I still don't really know that there's any other way to go about this. The other thing that I wanted to mention is not all of these cases, not all these lawsuits involve a counterclaim in the first place. There are some lawsuits out there where the defendant will just file an answer, and they won't have any claims that they want to bring against the plaintiff themselves. And so they just want to defend the lawsuit, and that's it. In those types of cases, the plaintiff can't file a reply to counterclaim because there never was a counterclaim. The last thing that I wanted to mention is try to understand that you will only get to reply to the portions of their pleading that are the counterclaim. So my ex filed an answer and counterclaim, but I do not get to reply to that entire pleading. I don't get to argue with and try to prove that her answers, her responses to my allegations are wrong or anything like that. The only thing that I get to address in this reply to counterclaim are the allegations that she has made specifically in the portion of that pleading that is the counterclaim. Have to underline this. I kind of touched a little bit on arguing, and I want to take an opportunity to add one more thing. try to resist the urge to try to prove your case right now in the pleading phase. There are some people who will try to attach exhibits to a pleading. That's wrong. That looks really weird, with rare exceptions. One of those exceptions is like in a medical malpractice lawsuit. You have to file like a physician certificate, you have to attach a physician certificate to the pleadings. And I guess what I could say at this point is, unless the law mandates that you attach some kind of exhibit to your pleading, don't do it. There will be times, opportunities that come up in the case later on that allow you to provide documentation and things like that, and this is not the time to do so. The pleadings are there to set forth what both sides are alleging they're entitled to, what both sides are refuting and admitting, and if you're filing a phone book size stacked pleading filled with like 36 different exhibits because you're upset at what your opponent is saying and you want to show the court right then and there that they're wrong, it's not going to look good, and it's going to annoy the judge and the court because they're not supposed to look at any of that stuff at that point. That's going to come up later. So it's important to understand the timing of the process, and at this point, as frustrated and as annoyed or panicked as you may be with what you're reading in your opponent's responses, resist the urge to turn your pleading into some gigantic essay response to your opponent's answer, or if they filed one, in this case, as my ex did, counterclaim. So I'm going to now proceed, and I'm going to remind everyone that hasn't seen my last video or that may have forgotten, the page and line numbers referenced in this video are referencing my filing, the reply to counterclaim. To keep track of where I am on my ex's filing, which in this case is the answer and counterclaim, just take note of the paragraph numbers that I am referencing in the reply to counterclaim. So let's move on. You'll see here that the introduction to the reply to counterclaim references specifically the date that my ex filed her counterclaim. This is an odd format, but because it's a self-help form, this is the way they go about doing it. Typically, a reply to counterclaim will consist of a list of sentences, and each sentence will specifically address a single paragraph. Typically, it'll be something like plaintiff denies paragraph 2, plaintiff admits paragraph 3, plaintiff denies paragraph 7. But in this self-help form, they just have broken it down into large sections where you can blob all of your admissions together, all of your denials together, etc., etc. In this self-help form, the first paragraph of my reply to counterclaim contains all of the paragraphs in my opponent's counterclaim that I admit to or agree with. It looks like I specifically have admitted paragraphs 2, 3, and 7 of the counterclaim. So let's take a look here. The top portion is the answer, so we're going to skip past that. Here we are, part 7. Or this is, okay, so this is the counterclaim. Let's take a quick look again, 2, 3, and 7. So paragraph 2 down here, that we were never married. I'm admitting that. Paragraph 3 is that we have a minor child together that was born on this date, which I'm admitting. And 7, that she should be required to contribute to the health insurance. So I'm actually agreeing with this. I agree that my ex will contribute to the health insurance and that I will pay half of the cost of the premiums. As I mentioned in my previous video, the law mandates this anyway. There's a statute that specifically forces the court to do this. And so it's not as though I'm agreeing just to be nice. Now, I may not know this at this point in time. I probably don't know anything about how the law works. So when I admitted or agreed to this paragraph, I probably was just doing it because I thought it was fair. But I know now, years later, that there are statutes that force the court to provide, or to force one parent to provide the health insurance and to force the other parent to pay for half of the premiums. So that's 2, 3, and 7. Let's move on. These are the paragraphs that I disagree with or deny. So 4, 5, 6, and 8. Let's take a quick look here. So paragraph 4, it says here that she is fit and proper to have sole physical and sole legal. So obviously I deny that. 5. In the matter of visitation with the father, she would request supervised visits are appropriate until I address my mental health issues. I went into a pretty long, I won't say rant, but I really wanted to underline how I felt about this accusation in my previous video. So definitely feel free to flip back to that video if you want to sort of get a reminder as to how I felt about this specific allegation here. But this one is adamantly denied. 6 and 8 also. So let's take a look at 6. That an award of child support per statutory provision is appropriate. This I probably denied because I had begun to learn about how joint custody works. Nevada was transitioning towards joint physical custody. So what I imagine here is that I anticipated a joint physical custody award, which was what I sought out, and for neither side to pay child support. This ultimately didn't happen, but it was not in favor of my ex that I'm going to say that. The court did order child support once I was awarded joint physical custody, but she was ordered to pay me. Paragraph 7, was that the other one? No, paragraph 8. That mother has been required to retain counsel and this is the attorney's fee request. Attorney's fees and costs request, which I also went into a pretty long, now that was a rant. I went into a rant in my last video about how I felt about attorneys and litigants who request attorney fees to be paid for by the other party who is so poor that they can't even afford an attorney. And I'm not going to go into that rant again, but if you wanted to go and see kind of what my opinion was on that, definitely watch my previous video, part 6. So I'm denying this as well. Moving on, you will see this third section. This is the section that you have no knowledge of, so you're forced to deny because you just don't know what the truth is, and you want to preserve your right to, at a later date, contest it. So here we have paragraph 1, that I have no knowledge of the allegations in paragraph 1. Okay, let's take a quick look here. Paragraph 1 says that that my ex is, and at all times she's been a resident of the state, physically present in the state for no more than 6 weeks prior. Yeah, I really didn't know because I didn't know where she lived. So that makes sense. That response makes sense. Scrolling down here, you will see that I have signed it and that I have verified it. Wait, is this this is not the verification. Well, it's a notary stamp. It's interesting that there is no, there's usually some kind of boilerplate that says something along the lines of that I swear under penalty of perjury that all of this is true and correct, and it's curious that there isn't one here. The other thing that I wanted to add, and I've mentioned this many times prior, is that later on these forms were changed to provide for declaration in lieu of affidavit, and that would basically save the the litigant time and money, because you wouldn't have to pay a notary public to stamp and sign it, and you also wouldn't have to spend time on setting up the appointment to go and meet the notary public. But I won't rehash that out in this video because it's come up so many times prior. Definitely, it's a thing to look into in your state. Try and find out if your state has statutes in place that allow you to just sign declarations instead of going out there and getting a notary to go out and sign your papers and pleadings and provide their little stamp and charge you and all that. Scrolling down, you'll see the affirmation sheet again. This affirmation is something that I've discussed also at length in my other previous videos. It's pretty standard for attorneys and for anyone who really prepares a custom paper or pleading to add little things like this to the actual form itself rather than dedicate an entirely separate sheet for it. And what I mean by that is you can typically just add a sentence to the actual paper or pleading that you're filing that says, you know, the language that you can see right here at line 5, the undersigned is hereby affirmed. In mine, I think I would put something like that the undersigned is hereby affirmed that this document doesn't contain the social security number of any person. This is really just something to protect people's privacy, and it doesn't actually protect it. What it does is it obligates the person filing to swear that they're protecting their privacy. But in reality, people could just file these forms and there could be social security numbers in their paper pleading, and unless the clerk finds it, they'll just trust that by signing this that you checked, and oftentimes it'll get entered into the case. So I'm trying to think, there is one more thing that I want to mention. Some people might wonder, why bother admitting anything? Why not force your opponent to have to prove the entire case, even the things that you know are true? The reason why is, and this isn't a really, well, I guess this is a pretty substantial reason. There's actually probably two reasons here. On the one hand, if there are things that are obvious and you admit to them, your ex won't have to spend time proving them, and if you lose your case, your ex won't have, and this, of course, we're talking about a child custody case, but you could apply this to any type of case. Your ex won't be able to argue for attorney's fees to prove something that you've admitted to in the pleadings. If your ex spends $3,000 proving something that you've admitted to, you could defend on opposition to a motion for attorney fees and say that all this work was pointless. If the court looks back to my pleading filed on this date, the court will see that I admitted to that. So why did they spend all kinds of effort trying to prove something that I've admitted to? The second thing is that there are areas of the law that will punish you for bringing claims that have no reasonable grounds or for defending claims without any reasonable basis. And so it's plausible or possible that your opponent can file a motion for attorney fees, and they could end up going back to your pleadings and citing them and saying that, hey, they denied this, this, and this, and when we got to court on it, it was so ridiculously obvious that they knew that that was true, that this court should punish them by forcing us to prove something that they really had no basis to deny. Just in case anyone's curious, that I know there are people out there who are wondering, why be nice and admit things? Well, the truth is, it's not really about being nice. There are consequences to denying things in these pleadings, and the consequences are pretty substantial. There are some cases where proper person litigants abuse this so badly that they're declared vexatious, and that their court access is restricted going forward because of that. So I'm going to move on now to 4 housekeeping pleadings. It's really only 2. There are some duplicate filings, but I decided at this point that I did not want to skip anything in the case. I really want this series to have every single filing in the high conflict, or yeah, in my high conflict child custody case. Every single filing in my experience, including ones that are duplicate. I'll just glaze over them if they're duplicate. The first one is not a duplicate. This is the affidavit of service. This affidavit of service is a separate filing, a separate paper that is telling the court that I filed my reply to counterclaim, sorry, not that I filed, that I served my reply to counterclaim on my opponent. If you take a look here, you'll see that it touches on 2 important areas. Number 1, are you a party to the action? Yes, I admit that I am. And number 2, are you, well, it's interesting, they broke it down. So typically, they will ask you if you are over the age of 18, separately from whether you are a party. But this is a kind of odd way of formatting this, because the second one here states that you are not a party to the action and you are over the age of 18 years. It's odd because this kind of implies that if you are a party to the action, that you can serve documents even though you're under the age of 18. And I'm not sure if that's allowed. But as I mentioned earlier, it's not really great to go in and use these self-help forms because they don't always make sense. And I've talked about in previous videos where there were some self-help packets that actually, like the contempt of court packet, that are actually deficient. And there were jurisdictional problems with that packet. I do recall that coming out and frustrating a whole lot of litigants because their motions for order to show cause were being denied, and they didn't think it was fair because they were just filling out the packet and following all the instructions, and they didn't understand why something was deficient or defective, because from their perspective, all they had to do was fill in this piece of paper and turn it in, which is absolutely not how the law works at all. But sometimes these self-help forms, not sometimes, always, these self-help forms cater to that idea that if you just follow instructions and turn in your papers, everything is going to work out a certain way, which is not at all what I have talked about in this channel. It's all about research and finding the truth out on your own. Another thing that I wanted to mention is that when you start preparing custom papers and pleadings, these these service certificates or affidavits or declarations, whatever you want to call them, these are typically included in the original paper or pleading that is filed. It's usually added to it, and you can find it typically towards the last page or two. Once you start to see my custom papers and pleadings in the future, you will see that I include certificates of service to those custom papers and pleadings, and that saves me from filing a separate paper on the docket. Here I am having to file this affidavit of service separately because my reply to counterclaim doesn't contain anything like this in that specific form. Had I prepared this myself, had I prepared the reply to counterclaim myself, I would have just included the certificate of service on the last page, and it would have specifically said that I had just mailed it to my ex. I'm going to scroll down here and see if it specifies how I served. It seems to. If the documents were served by mail on the other party. Okay, yeah, so this portion up here is a service by mail. And I haven't talked about this a lot before, at least not in the series. A lot of people who've watched movies like Pineapple Express, they will know that you have to kind of find your opponent and give them the papers physically. You have to like almost tag them with the papers. People make a game out of it even. But that is what, well, number one, that's Hollywood. Number two, that is actually what they call service of the initial pleadings. And in Nevada, the rules that discuss how that works are articulated under NRCP 4. NRCP stands for the Nevada Rules of Civil Procedure. When you serve other papers and pleadings after the initial pleading, those are served under NRCP 5, Nevada Rule of Civil Procedure number 5. And that rule is different. That rule does allow the litigant, if they want to serve the paper or pleading. They don't have to find a disinterested third party. That rule does allow the litigant to serve by mail. You just take it, stick it in an envelope, mail it to your opponent. Just like that, you have served a court paper. You don't have to track them down. Now, based on this affidavit, it appears to me that I actually went down to the lawyer's office and dropped this off. This is something that I don't encourage. Well, it's not such a big deal when you're serving an attorney, I guess. It's if your opponent doesn't have an attorney, I do not recommend serving them physically. You can do it under the rules, but it's a high conflict situation already. They're probably going to play a game of hide and go seek. They're probably going to say you're stalking them or harassing them. Avoid and bypass all of that stress by sticking it in an envelope and mailing it to their house. If they have an attorney, it's not so bad. It's not really a high conflict situation when you go to a law office and you drop off papers. But I typically, eventually, over the course of the years of representing myself, that emotional, visceral reaction to this process, my desire to show up in person and drop stuff off, began to fade. I didn't need to do that. That wasn't necessary. It was over the top. It would have been better if I just mailed this to her. I didn't have to show up in person and do that. So again, keep that in mind. Just because you can do something doesn't mean you should do something. I guess I could mention one more thing. Under the computation of time, if you do mail papers and pleadings to your opponent, you do give them an extra 3 days to respond. And I'm confident that I was not trying to serve my ex's attorney personally to cause a scene. Had I done that, I'm sure she would have made a big stink about it and called the police on me or 86'd me from coming into the law office. That's what they call it. In Nevada, it's a reference to trespass. But I never caused a scene. I never yelled at anyone, cussed anyone out. I would show up in person a lot, and for me, it was, I don't want you to get those 3 extra days. But really, it's 6 and they say it's a trade-off really, and it's an unnecessary drama. It's an unnecessary creator of drama, even though it's just a law office. It's better to just let them have the 3 extra days. I don't know how all the other states work, but in Nevada, it's NRCP 6E, which specifically states that they get an extra 3 days. If you haven't seen my video, Computation of Time, take a look at that video. I do know for a fact, 100% for sure, that for most of the first half of the case, probably years 1, 2, 3, maybe even year 4, I was serving documents personally whenever I could because I didn't want to give my ex's attorney those extra 3 days. I don't think it was me deciding that I wanted to disadvantage the attorney so much as I wanted a quicker decision. And it's crazy how my perspective has changed over the years, because initially, during those first few years, a day was precious to me. A day felt like a week, you know, when it came to getting a decision from from the judiciary. And later on, I became a lot more patient. And, you know, years 6, 7, and 8, I would file something and I wouldn't care if it took me 2 months to get a response. And I'm imagining that most of my viewers who are in the beginning phases of this process probably feel the same way. A day probably feels like a week. Maybe to some of them who aren't seeing their kids, maybe a day feels like a month. And so to even save 2 or 3 days is a big deal to a person who is litigating a case that is controlling how often they can see their children and to what extent they can parent them. So I do want to kind of, a little bit of a flashback there when I thought of that. I do want to mention that that was my primary motivation for personal service. But if your opponent, well, first off, try to just let that go and serve by mail. Second off, if your opponent doesn't have an attorney, you should really, really just serve by mail, and who cares how much extra time they get, because these situations are already volatile, and that's just going to add to the volatility. Okay, so notary public here. This is a little annoying because it's like I'm paying, and it may not be money. This particular person, Scott Crowley, I don't know if he was working the self-help desk, and he may not have been. If he wasn't working the self-help desk, then I would have had to pay a fee. But there's no point to, number one, there's no point to even having this separate form. This certificate or affidavit of service could have been included in the original pleading. And number two, even if I did want to file it as a separate paper, I could have just called this a declaration. Or I could have just replaced this portion down here with the language that I've discussed in my previous videos, that boilerplate language that allows you to use a declaration in lieu of an affidavit, and that would have saved me some time and money. Earlier on in the case, I just was used to going down to the notary for every single filing. Maybe it wasn't a big deal to me, but I do want to mention this to my viewers, because for some of my viewers, this might be one additional step that they just can't squeeze into a day. There are some people out there who squeeze this into their lunch hours, and it's tough to make 2 trips just to get a court paper filed when it's not necessary, when it's not required. Scrolling down, you'll see the gigantic full-page affirmation, which I've already talked about previously. It's just an unnecessary piece of paper. These are just so many reasons to go to custom papers and pleadings. So next we have my ex's attorney's notice of appearance. I discussed this in my previous video because I was mentioning how I don't believe they even have to file one of these. When they file a responsive pleading in a case, that should be in and of itself enough to make it clear that they are representing that party. So maybe she just filed this out of an abundance of caution. Typically, these notice of appearances are filed when an attorney jumps into a case in the middle of the process, not in the beginning. A notice of appearance, some of my viewers may have never seen these before. It's just a piece of paper that says, I, such and such, I'm going to be appearing on behalf of this litigant. And that's what she's saying. Kathrine Berning, the attorney, is notifying the court and me that she is going to appear on behalf of my ex, and she will be representing her. This also directs the court and myself to serve any papers and pleadings on my ex's attorney. I wonder if maybe she filed this because she was afraid that I wouldn't know that I needed to serve her law office with documents. It's possible that there were situations in the past where an attorney did not file this because they didn't have to, and then the litigant continued to serve documents on their ex, and then it created probably a whole lot of stress for that person who was like, hey, I hired you, you're my lawyer, why am I still getting papers? My ex is stressing me out, they're at my door right now beating on it. So it may be, I'm speculating here, I don't know why she went and filed this notice of appearance, but that might be out of an abundance of caution, that she just wanted to make it crystal clear to me that anything further would need to be served on her office. Oh, by the way, I did serve this on her. I did serve the reply to counterclaim on my ex's attorney. So even before I got this notice of appearance, I knew what I was supposed to be doing. This is just certificate of mailing. You know, I just talked about this. I talked about how you don't have to file a separate piece of paper to tell the court that somebody was served. And here is my ex's attorney preparing. By the way, this is a custom pleading or custom paper. This is not a pleading. This is a custom paper. This notice of appearance has no blanks on it aside from the signature line. My ex's attorney typed it up custom, and right here at the bottom is a certificate of mailing. And right here it states clearly that she has served me. And probably, oh, look at this, NRCP 5, I was just talking about Rule 5, and that it was served on me by mail. I was not personally given this. It was sent to my mailbox. So this is a great example as to what I was just talking about. Now, she doesn't have to file an entirely separate piece of paper. And look at this, no notary stamp. So that saves the lawyer $5 right there. I don't know how much it was. I think it was $5 because she didn't have to get a notary to stamp it. So here's, okay, so interesting. She does attach the affirmation sheet to the back. She didn't need to do this. This could have just been included as a one-line sentence right about here. That would have been just fine. And in fact, she probably, or not she probably, from what I recall, she does do that for the most part. I don't know why this notice of appearance is done so helter-skelter. And it's actually a good way to characterize this because the next document is the exact same thing. She filed it a second time. The exact same thing. I'm not going to really talk about it because it's identical. Oh, wait a minute. No, it's not. Different address here. I'm going to scroll back a second. This looks like my workplace. She may have sent this to my workplace. This looks just, it jumps out at me as Circuit City's address. I'm going to double check this in a second. So it was not pointless. This is not a duplicate. She is swearing that she sent this notice of appearance to my address. And this is my residence right here. This, by the way, this is ancient history. I don't live here anymore. This is 8 years ago, or wait, 11 years ago. I don't know why I said, oh, 8. The number 8 stuck in my head because that's how many years I was representing myself. Anyway, this address is where I was residing. This other address here is where I worked, I think. I'm going to double check in a second. And this is the third one she filed, which is also identical. Or at least it seemed to be identical. I'm going to check it out again. Okay, so this one is identical. This has my actual address. So it looks like they got a little bit confused as to where I lived. And after I finish this video, I will post down in the comments below if my ex's attorney mailed one of these to my workplace. But that's just, if she did do that, that's kind of not cool. I don't think I would want my employer getting court papers for my child custody case at my place of work. I'm going to definitely check that out. I'll post down in the comments below. So check the comments and you'll find out if if that address right there was my work address, and if that's where I got served, I'll let everybody know. I'm trying to remember if I recall that, and I kind of do, but it's really fuzzy. So I can't say for sure. Going into the aftermath, I just want to state that it did not cost me anything to file this reply to counterclaim, so you're not going to see any of the numbers change on my end. My ex's attorney would have probably put about, we'll say 15 minutes into the notice of appearance and to review my reply to counterclaim. It's tricky, but I don't think she would bill an hour for that. She probably billed like 45 minutes. So that's going to bring a total of 1 hour's worth of attorney fees for my ex, which I have kind of guessed to come to $250 an hour. And I kind of based my reasoning on the fact that the attorney that she hired wasn't really one of the cheaper ones that charged less, but she also wasn't one of the hotshot ones that charged $350 or more. $250 sounded about right for the attorney that she hired. So that's going to increase her attorney fees by $250. And With that being said, if anyone has any questions or comments about this specific video, it was mainly just me filing the reply to counterclaim. Didn't really have a whole lot of detail, or didn't really have a whole lot of memory or anything about my mindset that I really haven't already covered in the previous 2 videos. So definitely let me know if there's any questions anyone has, anyone's curious about anything. As with my previous videos, you can download these papers and pleadings by clicking on the links in the description below. And with that being said, I will see you guys next time.